He, all persons having business with the appellate division are here. Your attendance shall be heard. Please be seated.
Welcome to the Appellate Division, First Department. We have over 6 hours of argument time requested, so please ask for the argument time that you need, not what you wish. We are familiar with the briefs and the records, and if you have more questions, we will keep asking them. People versus Echevarria, submitted. Good start. Bronx Coalition versus New York City Department of Planning. Nobody's hearing that? Okay. Submitted. A. Isabella is submitted. Ahmed versus Metropolitan Transportation Authority. Okay, that is also submitted. Dixon versus Afternoon Delight is 2 cases. Even though normally I put them together, I'm going to keep these 2 separate since they really are separate issues. So let's start with number 5, which is the appeal by Afternoon Delight. Appellate? What? Okay, and respondent? And how much time are you requesting?
5 minutes.
You're not on that one, right? You're on the next one. Okay, I'll call that one separately. Do you want, I'm sorry, you didn't put in papers on the first motion, right? Yeah, no, you said you're not taking a position, so you don't, yeah. Did you want a minute because you have a cross appeal? On the cross appeal?
A minute's fine on the cross, or I can address it on.
If you don't need the time, that's fine. We'll just give you 5. Okay. Now I'm calling number 6, Dixon versus Afternoon Delight. Appellate. And there are 2 respondents on that. Afternoon Delight? And Castillo? Okay, I'm going to give you 6 and 1 for the city, and I'm going to give each of you 4 minutes because you're making the same arguments, and if we need more time, we'll keep asking questions. People versus Murray. Appellant?
Good afternoon, appellant request 5 and 1.
Respondent?
Respondent request 5.
5 and 1 and 5. Preferred term securities versus ACP. Appellant?
Appellate request 5 and 2, Your Honor.
Respondent?
Your Honor, I'd like to introduce my partner, Susan Lang, California attorney, who's filed his pro hoc papers and requests that the panel allow him to argue this afternoon.
That's fine.
Thank you, Your Honor. Respondent would request 5.
Okay, 5 and 2 and 5. 99 Wall Development versus Consigley.
Respondent, appellant.
Are you? Well, let's hear first from the appellant. You're the appellant? What? You're the appellant. Okay, and you're requesting 4 and 2? And what are you requesting?
5 and 1.
Okay, 4 and 2 and 5 and 1. Armani? Okay, no one's here. That is submitted. Fields versus General Conference and Pertardi, those are going to be argued together. Appellant? Is the appellant not here? You're the respondent on both of them?
2 minutes.
Okay. Doctors Allergy versus Valiant Pharmaceuticals. Appellant?
Yes, Your Honor. For the appellant, request 5 and 2.
Respondent?
Your Honor, my name is Thomas Embry. I'd like to introduce co-counsel Alan Sharp, California attorney, and the pro hoc each Owings, Securities.
Request is granted.
Respondent request 5.
Okay, 5 and 2 and 5. Van Boxell versus Van Boxell, appellant. Respondent. 6, 1, and 5. People versus Mena, appellant. Is the respondent not here? Okay, it's submitted. Weinstein versus E-Trade Securities is submitted. Melendez versus 106 is submitted. Skidmore Owings versus Merrill, and Merrill versus New York City Tax Appeals, appellant. Respondent?
Respondent request 10.
Okay, I'm going to give you 7, 1, and 7. Again, if we have more questions, we'll keep asking them. Okay, so the first case is the first Dixon versus Afternoon Delight, which does not involve the city.
Good afternoon, Your Honors. Monica Romero for Afternoon Delight. I would like to focus on 2 points. The first one is that we do believe the Supreme Court abused its discretion by raising an argument and granting relief and dismissing the deli as a defendant on that basis. We do believe that if that would have been an argument raised by the parties, then we would have argued that...
Didn't you both have an opportunity to discuss it and make your arguments about it once the court raised it?
We didn't conduct any discovery or any legal research or any factual development through the briefings or motions for that argument. Nobody raised it, not...
Why is there any factual issue? I understand the issue that the court raised was that the deli is not a signatory to the lease. So what, and that's undisputed that the deli is not a signatory to the lease. So what factual issue would you wish to develop regarding that?
We do believe that Ms. Castillo signed the lease in her capacity as a representative of the deli, of the business.
Can't we determine that by looking at the face of the lease? Because it has to say something about that on the lease itself for that to be the case. And the court and we can review the lease and see what the lease does or does not state.
Yeah, we do believe that because the lease states that it's a commercial lease, the lease states that the property is going to be used as a grocery store. It is outlining the purpose of the space to be for a business. Additionally, the insurance that she procured lists the deli as the insured party. It doesn't list Mary Castillo.
Right, but if there's no ambiguity on the face of the lease, why would a court look beyond what the lease itself says?
Yeah, we just believe that had we been allowed to conduct any discovery, to ask questions during the deposition about her intent in signing the lease and if she was trying to do this as a representative of the business, then...
Okay, do you want to address the indemnification issue and the issue of whether or not there's ambiguity in terms of what the indemnification does or does not cover?
Yes, Your Honor, that would be my second point, which is that the deli can still be liable to plaintiff under 2 theories, which one is respondent superior and the other one is under Espinal. And we understand that Castillo and Ms. Castillo and the deli have raised the argument that the lease is contradictory, but we do not believe so. We believe that the lease is consistent.
So you're saying the deli or the owner?
The deli. I'm sorry, what are you...
The deli is not the owner, right? The deli is the lessee, but the owner is the owner of the property, right?
Right.
And you're saying the deli could be liable?
Yes.
What duty does the deli have?
Well, if the deli owes a duty to its patrons.
Under what? Under
This
what
common
theory?
law.
It's not the owner of the property, not the lessee of the property. What theory would the deli have a duty under?
Responded superior vicarious liability, the work of its employees.
I don't understand. Respondent superior means that it would be connected to someone that owns it, right?
Yes, it's
So who owns the deli corporation?
Mary Castillo.
So she's already a defendant, right? So how could so that doesn't work. And then what was the other theory you were talking about?
Espinal, which is under the contract, would be, I'm guessing, under the assumption of the court, Mary Castillo.
So you're saying that the deli created the harm? There's an issue of fact as to that?
It could be liable to plaintiff because it is the occupant of the premises.
No, but right, but it does. I can occupy, right? There has to be some legal basis for the duty, and since that occupant doesn't have a lease and it's not the owner, I'm trying to figure out what the duty would be.
Right. I do think we briefed the issue, Your Honor, that stores have a duty to the
Oh, for sure, stores have a duty, but usually the stores are the lessee, right? Here, the lessee is the owner of the deli, not the store.
I am not aware of the distinction.
Okay.
To be
Okay, and you have 3 minutes on reply, so we can delve into that further if you wish. Thank you.
okay.
Good afternoon, Your Honors. John Anello from the law firm of Callahan and Fusco, and I represent the respondents, Mary Castillo and the Fifth Avenue Deli Mart Incorporated.
Let me ask you, why does the ambiguity, if to the extent we believe or agree that there's an ambiguity in the lease, why does that entitle your client to summary judgment as opposed to it being an issue of fact, which ultimately gets decided down the road?
Well, Your Honor, what I wanted to focus on here was the fact that this Supreme Court erred in entering summary judgment in favor of Afternoon Delight with respect to indemnification, defense, and
Or
insurance.
you don't want to pursue your other argument? Okay.
Well, I'd like to
It's
focus
an
on,
argument you made, but you don't have
I'd like to focus
pursue it
on
if you
that,
don't wish.
Your Honor, because it might be an issue of fact. But here, the alleged defect is that there was soil erosion caused by a leak from either a storm basin or a fire hydrant or something with the sewage system that caused a depression in the sidewalk, which ultimately led to this alleged slip and fall by the plaintiff.
Well, that's one theory, right? But
That is one theory, but that's also the theory that's been advanced by Afternoon Delight through their expert, Mr. Cameron, who reviewed these materials and came to an expert conclusion.
Isn't the real question, though, who is responsible under the lease for these repairs?
Yes, Your Honor, and our argument is that we are not responsible because this type of defect is beyond the scope of anything.
What about Article 30, which says that the tenant is responsible for all repairs to the sidewalk, and it doesn't have any limitation to structural repairs? Why doesn't that support Afternoon Delight's argument that the tenant is responsible?
Well, I think if you take a look at Article 30, Your Honor, it talks about cleaning the sidewalk, and it talks about things that.
Article 30 talks about more than cleaning the sidewalk. It's broader than that.
But I think if you look at, if you take the doctrine of assutum generis, which Afternoon Delight cited to in its papers, it talks about cleaning the sidewalk. It talks about snow removal. It talks about keeping it free of debris. So I think repairs, to the extent repairs or maintenance is required, I think you'd have to read it in the context of.
Well, repairs certainly means something other than just cleaning.
I think it does, but when we're talking about repairs with a defect of this kind.
Repairs and replacements, wouldn't this be a replacement?
I don't think so, because based on Afternoon Delight's expert testimony, they are precluded under New York law from, as the owner, from doing anything or fixing this property. So how would their tenant be responsible?
They're
doing
precluded
this type of repair?
from fixing the leak maybe, but they're not precluded from straightening out those broken up pavers.
Again, fixing the broken up pavers, I don't think is within the scope of Article 30 of the lease, because we're talking about repairs, maybe patchwork might be, but a repair of
Why
this
wouldn't that
kind-
be repairs and maintenance?
What's that?
Why isn't there a question as to whether or not that would be encompassed under repairs and maintenance?
A question? I
Why
don't,
isn't that a repair under Article 30 of the lease?
Yeah.
because I think it's far too onerous to put on a tenant, and if you look at the cases
Replacements,
that
it doesn't just say repairs, it says replacement. Isn't this replace the pavers that are broken up?
it seems like it's more than replacing the pavers. We're talking about soil erosion, potential leaks. I don't think the landlord or the tenant, frankly, contemplated
So you
that.
couldn't get to the underlying cause of the problem, but you could ameliorate the existing problem and for a while eliminate the problem.
I don't think that's within the scope of the lease, nor is it within the case law that we cited to Wolf and Cunanata. Those cases stand for the proposition that we're not, a tenant is not responsible for undertaking.
Because you're arguing that there's structural, that's what I'm trying to,
repair
right.
work.
Okay,
Yeah,
you're
structural
saying that
repair work, and it
replacing
talks
those
about that in-
those pavers is structural and not ordinary repairs.
That, I think this is certainly would qualify as a structural repair, taking up pavers, dealing with soil erosion. That, I think, certainly constitutes a structural repair. And the cases that we cite to Wolf, Cunanata, the cases that are in our brief certainly point to that. And if a tenant is to undertake the obligation or the duty to make structural repairs, they're certainly required to spell that out clearly in the lease. We
And
don't
is
have
it is it your position that the owner is, under this lease, is responsible for structural repairs?
Yes, I think that's apparent from paragraph 4. At best, I think this is it might be ambiguous as to structural repairs, but
Thank you.
certainly under paragraph 4, it would be the owner's responsibility. Thank you.
Your Honors, I'll continue with my point, which is we do believe that the tenant is displacing our duty to maintain the sidewalk under Espinal. And we do not believe that the lease is contradictory by its terms at all. We think Articles 4 and 6 delegate the responsibility for the maintenance of the sidewalk to the tenant. And while Article 4 states that the owner shall maintain and repair public portions of the building, we believe that refers to areas like the lobby or the hallways or stairways. We don't think that refers to the sidewalk, which Article 30 controls. To the extent that there could be any contradiction in the lease, the specific controls are general. That's just, so Article 30 would control the lease, which is the specific provision governing the maintenance of the sidewalk. And I think that would be our position in terms of the lease.
Thank you very much. The next Dixon versus Afternoon Delight.
Good afternoon, Your Honors. My name is Amanda Abata, and I represent the City of New York. This court should reverse Supreme Court's decision because the city's entitled to summary judgment. Quite simply, the city had no duty to maintain the section of the sidewalk where Mr. Dixon fell and was injured. Under the
Let me ask you something. Did anybody address liability for a condition which may have been caused by something in the catch basin and how that should be handled?
Well, with regards to the catch basin, there are a couple points that I want to make in terms of if you're referring to a party's argument that somehow the city's catch basin sort of created the soil erosion that caused the deterioration of the sidewalk. As Your Honor started to speak of in the prior case, like that, or one of Your Honors, that's a sort of like speculative conclusion that was arrived to by Afternoon Delight's expert. He specifically, 8 years later, when he conducted his review based on looking at various photos and whatever other things that he looked at, he alleged,
Let me step back a minute, though, because the question I'm really asking is, has anyone addressed who would have responsibility for an issue in the catch basin, if there was an issue in the catch basin. Does anybody in any of their briefs address that?
Well, we feel like it's addressed by the fact like it comes up here. Specifically, the sidewalk is the responsibility of the adjacent property owner. And an exception to that is if the city caused and created it, which they're alleging here with the leak in the catch basin. But we're saying that that does not create an exception to the responsibility of the property owner to still maintain and or repair and replace those sidewalk panels, because even if it wasn't speculative that the catch basin leak caused the soil erosion, that is a gradually developing condition that the city cannot be liable for here under the affirmative negligence
Because it
exception.
has to be an instantaneous thing.
It has to be an immediate, yes, Your Honor. There's countless cases that says that it has to be an immediate action of, or something that causes an immediate dangerous condition.
And sort of that erosion is like wear and tear. So
Yes.
it doesn't matter whether it's erosion because of this or that or the other thing. It happens over a period of time, like most wear and tear. And
Exactly.
it wouldn't constitute
Exactly that, Your Honor. And this is what I wanted to say earlier. Mr. Cameron's report, like I said, compiled from a review of various documents 8 years after the accident. He says that the defect did not appear to be related to other common sidewalk failure mechanisms. He then theorized that the nearby hydrant and stormwater catch basin and associated manhole cover appeared to be the logical source of water for subgrade erosion. And then he said it cannot be ruled out that a pinhole-type leak existed below grade, which leaked over an extended period of time to cause soil erosion under the pavers, and that leaks are not uncommon due to long-term wear and tear. So we maintain that, like, even if that theory could be given credence to, that doesn't create any liability for the city here. And outside of that, Afternoon Delight, as the property owner under the sidewalk law, has a duty to maintain that sidewalk. And the only exception to that is if Dixon fell within 12 inches of the city's utility,
There's
which
no dispute in this case that it's not within 12 inches.
There-
Even
absolutely.
the plaintiff testified he was 4 feet away, right?
exactly that. He marked up several pictures, and the city's own investigation and indeed the expert witness from Afternoon Delight also essentially reached the same conclusion. So there's that. The other argument that I wanted to address that the other parties make has to do with prior written notice. And as a first, it's worth noting that prior written notice doesn't apply to the facts of this case unless Dixon fell within 12 inches of that manhole cover or the adjacent property owner is exempt from liability under the sidewalk law, and none of which is the case here.
because the plaintiffs didn't make any argument that you had special use or anything like that, which could conceivably bring up a notice requirement.
Yeah, they didn't plead and/or argue special use, and like I said, they tried to make the cause and create argument, but that's defeated essentially by the fact that even if their theory is correct, there's countless cases that said any gradually developing condition like that doesn't create liability for the city here. And I just wanted to make a couple more comments with regards to Ascani Castillo's July 26, 311 call. They're saying that it's prior written notice, which it doesn't apply here, but if this court were inclined to say that it did. That call, as we know, like a verbal communication reduced to a writing isn't prior written notice. That call also isn't a written acknowledgement of a sidewalk defect, because in order for it to be such as that, the city's records would have to indicate acknowledgement of the defect that caused Dixon's injury prior to his accident, which is just not the case here. Like,
No, please, finish the sentence, then I have a question for you.
oh, no, that's good a place as any to
Yeah.
conclude.
So let's go back to the leak, right? The accident took place in August.
Yes, Your Honor.
Now, there was a dye test that was performed that indicated that a leak occurred, but it was after the accident, I believe.
Yes, in September.
Okay.
Yeah, a month later it happened based on, there was a second call to 311 from Mr. Castillo on the day of Dixon's accident after his accident. So that obviously brought a second inspection, and it was at that time that they performed the dye test. Yes, Your Honor.
Thank you.
Thank you. You go.
Your Honors, the city relies solely in one argument, that they are not responsible because Mr. Dixon did not fall within 12 inches of the manhole cover. That is unavailing because the defect is under the manhole cover. It's in the catch basin. And it's not just our expert, it's two representatives of the city that were present for deposition stating how the dye tests work, reviewing the reports that were created from the emergency command control.
That goes to the question I asked the city. The statute clearly says that the city is responsible for the perimeter on the sidewalk 12 inches around the manhole cover. That particular statute does not say anything about catch basins or things going on underneath the street. So where is the argument in your paper about how liability comes to the city for an issue which may be going on underneath as opposed to within the perimeter? Because that statute doesn't apply to underneath.
First, I do, well, if you consider that the defect is under the manhole cover, right? If it's in the catch
But
basin.
that's not what causes the fall.
I'm sorry?
That's not the defect that causes the fall. That's the underlying cause of the defect, which is present someplace else.
Right, but it is necessary to fix the defect where the accident happens, right? Like,
But all we have is a statute that talks about the 12-inch perimeter around the manhole cover. You haven't shown us a statute, or you haven't shown us authority for what their liabilities are with respect to issues going on underneath the manhole.
well, I think that we have shown authority that it is the city's duty to maintain and do
They
regular.
didn't have notice about this defect, did they?
We would argue that they did. We would argue under Bruni, the Court of Appeals has held that any internal records that the city has acknowledging a defect, that constitute written notice. And additionally, there was a previous
How did
lawsuit.
that record come about?
I'm sorry?
How did that record come about?
How did the report come about?
How did that record come about? You say there's a record of a
Yes.
defect?
Yes.
What's the record?
It was a call, and then it was.
But
it
a
was
call
report.
doesn't constitute, it's been held that a call doesn't constitute prior written notice, even if the call is reduced to a writing. Even if someone on the city side reduces the call to a writing, that doesn't turn that into written notice.
We believe that the record that it was made from the call would constitute that under Bruni. But there's also the
There's
lawsuit.
case law that says that that's not correct, right? There's case law, lots of case law that says that even if somebody writes down what happened in a phone call, that's not written notice. So what are you supporting that with, that
Even
statement?
if that were the case, there's a previous lawsuit. There's a previous lawsuit bringing about the same defect to the
It
city.
is not in the same area.
It is the same area. The exhibits that were submitted for that lawsuit is the exact same defect. You can see the pictures depict the exact same area in that lawsuit. So they had noticed. Additionally, there's a transcript of Mr. Pimentel that he would discuss with city representatives that he was not allowed to fix the sidewalk because he could not have access to the sewer. They have sole control of the sewer and the man cover.
Thank you.
So that could not be something that they could fix. Thank you.
No, he goes.
No.
He goes.
Oh, sorry.
He goes.
I think, yeah, he said it.
Oh, you submitted on this one? Oh, okay, I thought you asked for 4 minutes of time. Okay, but you submitted. Okay, sorry about that.
Apologize, Your Honor.
Counsel, can you respond to your friend's assertion that the area in the prior lawsuit is the same as the area in this action?
Well, that's just categorically incorrect, Your Honor. Like, and if you compare the exhibits from Ms. Moses's lawsuit to Mr. Dixon, you can see that they're not in the same location. They point to different defects on the sidewalk. We all agree that Mr. Dixon's fall was from an alleged defect that was at least 4 feet away. Ms. Moses's was much closer, but none of it really matters with regards to the city's liability because both of them are outside the 12-inch radius that the city is responsible for.
There isn't really an issue about the 4 feet, right? That's an uncontroverted fact.
There's no issue.
Because when you look at the picture, it looks
Yes.
a lot closer.
Yes, Your Honor, like there's no issue of fact with regards to that. So yes, so contrary to my friend's assertions, the lawsuits from Moses and Dixon shows that the defects were in different areas or pointing to different defects, and with any regards anyway, they're outside the 12-inch radius that the city is responsible for.
Thank you very much.
I rest on my brief. Thank you.
People versus Murray?
Good afternoon, Your Honors. Nkekshi Irandu for Appellant Dwayne Murray. We are asking this court to reduce Mr. Murray's 5 to 15-year sentence in light of Mr. Murray's significant mental health illness and the unusual and unique circumstances of the incident. The combination—
So wasn't all this taken into account by the court? This was a very, very extensive negotiated plea, wasn't it?
Yes, the court was aware, but this court has the authority to reduce sentences in situations such as this, where the appellant, in this case Mr. Murray, had significant mental illness and a long history of hallucinations and delusions, and so significant was his mental illness that the lower courts, the prosecution, and both the prosecution and defense experts acknowledged it. Even the lower court going as far to say that if Mr. Murray's case was to go to trial, a jury could find—
This went to the issue of what appears to have been a consideration of perhaps raising an insanity defense, but at the end there was a determination that that was not going to be pursued, that the plea was going to be taken, and Dr. Goldsmith said the defendant knew the consequences of his conduct at the time he did it. I mean, this was a plea taken over the objections of the family of the victim. There was a lot of consideration. There was pretty compelling evidence. Wasn't there a video of the defendant in bloody clothes? And he faced a lot more time. I mean, this was a murder 2 reduced to a manslaughter 2. All of this was taken into consideration.
Yes, so all of the mitigation was at the table when the plea was taken. However, this court has acknowledged in the past that in situations with mitigation such as this, specifically the unique circumstances of the incident, Mr. Murray was in his apartment when someone broke in, and he was understandably fearful when he received threats from that person's friends and family and acquaintances, including Mr. Nichols, the ultimate decedent in this case. And so he acted out of genuine fear for his life and for his safety.
No, he chased the victim, right?
Yes.
Chased the victim. He wasn't afraid. He chased the victim.
And Mr. Murray's actions in that state—
And also, let me just, because yes, he did, okay, but let me ask you, he waived his right to appeal, right?
So we are arguing that the appeal waiver was invalid because—
Why?
Because the court failed to sufficiently distinguish between Mr. Murray's right to appeal and those rights automatically forfeited upon guilty plea. The only language that
But the court did in taking the waiver, besides that the written waiver it certainly deals with it, but even the oral waiver used something like the word separate right. It may not have been the typical language used, but it didn't conflate the waiver, the plea waivers, and the waiver of the right to appeal.
So the only language—
And there was a lot of time given. The record reflects that the court made sure that the defendant discussed this with his attorney and they conferred about it.
So it's incumbent upon the court to ensure that the person taking the plea understands the rights that they're giving up. And the only language that the court uses to sort of get at this distinguishing is that Mr. Murray was giving up his right to appeal, and that was, quote, not a right that you just give up because you plead guilty. This language is unnecessarily confusing, especially for someone like Mr. Murray entering his first
But he had the
guilty plea.
written waiver, right, which says that these are separate and distinct, and the court made sure on the record more than once that he discussed the written waiver with his attorney, and that he understood the terms of the written waiver, and that he agreed to it and didn't have any questions about it, correct?
Yes, Mr. Murray
And he signed it, correct, with his lawyer?
Mr. Murray did sign it before the court gave its colloquy, and this court has found that a written waiver.
Why shouldn't we
I'd
believe
like
that?
to go back. Justice Scarpullo,
No, I'm just saying, why shouldn't we believe that he understood it? He knew what he was giving up. He expressed it many times on the record. He discussed it with his lawyer. Why would we disregard that?
So the totality of circumstances we really have to look to. We have to look to the fact that this is Mr. Murray's first conviction, entering his first guilty plea, and in a lot of ways he might not feel comfortable saying, no, I don't know, I don't understand.
I'd like to go back and pick it up from Justice Scarpullo, because defense counsel acknowledged that he discussed the waiver with the defendant, correct? Yes?
Yes.
Okay, and then even pause to discuss it again. Am I right about that?
I believe
That's usually a yes or no, but spoke to the defendant, acknowledged, and then paused and spoke again. Is that right?
So again, while it's true that Mr. Murray already had signed the appeal waiver.
No, but I'm saying twice. Let's deal with that. Acknowledged that he spoke to the client, right? You already said yes to that. And then again, paused and spoke again.
So again, while that does seem to be reflected in the record, it really is incumbent upon the court to deliver a colloquy that is clear and that does the work of distinguishing the right to appeal from those trial rights automatically forfeited through guilty plea, and I will respond to further questions on my rebuttal.
Good afternoon, Your Honors. Andrew Loizidis for the respondent for the Office of Darcel Clark, and may it please the Court. Your Honors, as we just pointed out, the defendant knowingly, voluntarily, and intelligently waived his right to appeal. As Your Honors just pointed out, the Court made sure that the defendant went over the written waiver of appeal with defense counsel, that defense counsel acknowledged on the record that he explained everything.
Twice.
Twice, yes, Your Honor. Thank you.
Counsel, and this was negotiated?
Yes, Your Honor.
Forth over several adjournments,
Yes,
correct?
Your Honor. Yes, it was.
And he got 5 to 15 on the first felony, correct?
That's correct, Your Honor.
Someone died, correct?
That is correct, Your Honor. And when the top charge was second-degree murder, and had he been convicted of second-degree murder, he faced the potential sentencing range of 15 to life to 25 to life. But after a carefully negotiated plea sentence, which the lower court actually asked the prosecution to explain why was this in the interest of justice, and as, again, all those mitigating factors that were taken into consideration, the defendant's psychiatric history, all that taken in.
And the victim's family was against it.
Very much so. Yes, Your Honor. Very much so.
And was there any doubt that was the evidence strong that this person had committed this act?
Yes, yes, Your Honor. The evidence was very strong. Everything was, we have video surveillance. I caught everything. We have a record that established he did this. And as to his psychiatric history, there was conflict. The defense's psychiatric expert and the prosecution's psychiatric expert were contradicted one another, and therefore there was no insanity defense that could be raised on this, and ultimately it was just determined that the defendant knowingly, again, waived his right to appeal. Everything on the record was established that he knew what he was.
Is there any evidence that Mr. Nichols actually threatened the defendant?
That he
That the victim threatened the
no,
defendant?
there was no evidence that established at all, Your Honor. In fact,
Was there any evidence even that the decedent had a weapon of any kind?
no, nothing at all. Nothing at all. Unless Your Honors have any further questions, I respectfully submit on the rest of the brief.
Thank you very much.
So, counsel, let me just ask you, why isn't a sentence of 5 to 15, which is substantially lower than the 15 to 25 that he could have gotten, why isn't that a fair sentence?
This court aptly acknowledged that default incarceration for crimes caused by mental illness is antithetical to the interests of our penal system. And this aligns with studies that show that incarceration poses significant challenges to mental health treatment and sometimes can even exacerbate it. And so Mr. Murray, it's clear through the record that Mr. Murray has severe mental illness and has been dealing with this severe mental illness for his entire adult life, has been managing it. And the fact that this is his first conviction, I think, illustrates the fact that he has been functioning in his community and managing it to the best of his ability. And incarceration is...
This wasn't the first instance of violence, though. There is a history of violent threats against hospital personnel, isn't there?
So while Mr. Murray has had incidences of violence and acting out, that has never, it's always led to in hospitalizations rather than arrests, and has always been sort of a result of him responding to perceived aggressors. And so
Thank you very much.
we respectfully ask the court to reduce the sentence in the interest of justice.
Preferred term, Securities versus ACP.
May it please the court, William Adams for defendants' appellants. The trial court erred in allowing plaintiffs to hold 3 defendants,
Counsel, this case sounded very familiar to me when I started reading it. And I realized the reason it sounded familiar is because I was on the other case where we already decided this issue. And I am wondering about your argument that we didn't address this issue before, because I went back and looked and said, oh my goodness, did we miss this issue? And arguably, we did address this issue before in what we found. So I would like you to address that.
Thank
Why
you.
this wasn't decided before in our prior decision.
Absolutely, Your Honor. This case is familiar in many ways, but not in any way that is dispositive to this appeal. In the prior appeal, defendants moved to dismiss the contract claim based upon the terms of the successor obligor clause. The trial court denied that motion, and this court affirmed.
Well, let me get more granular, okay? I'm going to quote from our prior decision. Nor does the plain language require the finding that the transactions did not trigger the provisions based on the fact that there was no execution of a supplemental indenture as to failure to execute a supplemental indenture in connection with a merger where the issuer was not the surviving corporation would have constituted a breach of the requirement by the merger counterparty to execute such a document. Why doesn't that address the very argument that you are raising here? That
Your Honor,
you're saying
because
we didn't address.
Because that turned on the express terms of the successor obligor clause, which is reprinted in the appendix here at 217 to 218. There is a separate, I would say, antecedent legal issue as to that means regardless of what the clause says, regardless of the terms of the contract, New York law does not permit contractual liability absent an express agreement to those terms, an express
So let's assume that we don't agree with that, because there are plenty of situations where people are held to contractual obligations when their name isn't on the document, right? Let's agree to that.
I can agree to that, Your
Okay.
Honor, yes.
So if that's your only argument, that under New York law, you could never be held to a contractual obligation that you didn't actually execute, then I have to say that that's not a particularly, first of all, I don't think that's the law. I don't think you think that's the law. But is that it? Is that all you have?
In this circumstance, Your Honor, there are 2 bases that plaintiffs are relying on to extend the payment obligations to the 3 of the defendants here, TGI, TGIL, and ACP. One is direct contractual liability. They're saying under the terms of the contract, you are successors, and therefore you're bound as a matter of direct contractual liability. We think that is what this court resolved the express terms of the contract last time, but did not resolve the antecedent issue that you have to have an express assumption. Separately, there are issues of common law successor liability. Absolutely agree. There could be a common law theory, and they are pressing a common law theory.
Didn't we expressly hold in the prior decision that you did not need to execute a supplemental indenture for there to be liability? Isn't that the exact argument you're making now? you do have to have something in writing?
We do have to have something in writing, but Your Honor, that was based upon the terms of the agreement. Respectfully, there was no, I argued the last appeal. I was here last time before Your Honors, and we did not make an argument on appeal that you had to expressly assume the contract. You had to expressly assume the contract. That's an antecedent issue under New York law. The Court of Appeals in Silman and in Nicholson has been very clear that there is no contractual liability for non-parties absent an assumption. And it's particularly clear under the Todd case, that's from the Third Department, an amalgamated
You're saying you
transit.
didn't argue that to the court below in the prior appeal? You never made that argument to the court below in the prior appeal, the same argument you're making now?
To the court below, the court below did not resolve this issue. The principal argument to the court
Why
below.
I looking at things that feel we did resolve the issue by saying you don't have to do a separate writing to assume liability.
Respectfully, Your Honor, that was tied to what the successor obligor provision itself said. You said that under the terms
You're
of the...
saying under common law, there should be a different result.
I'm saying there's a superseding principle of New York contract law that requires an express assumption. And that is regardless of what the terms of the contract say. And you can look to the Todd case from the Third Department, the amalgamated transit case from the Second Department, and those say that even if a contract purports to bind successors, it doesn't absent an express assumption by the successor. Thank you.
Good afternoon. Timothy DeLang from the law firm of Wilmoth, Marr & Deutsch. Thank you for allowing me to argue today, and may it please the court. I don't think it's going to come as a surprise that I agree. This issue was fully litigated. Justice Borak actually quoted from their brief before him. I just want to remind you of exactly what they argued, which was, but a contract only binds the parties who agreed to it. Non-parties like TGIL and ACP cannot be liable for breach. That is from defendant's brief in the first, the underlying briefing in the first appeal. That was brought to the First Department. That issue was decided. We would submit that it's correctly decided. These cases are proceeding in the Supreme Court. In fact, as we stand here today, the parties are finalizing summary judgment motions that are being filed in those cases. We submit that the law of the case, collateral estoppel, this has already been decided.
Thank you.
Unless you have any further questions. Thank you.
Thank you.
I recognize I have a tough argument to make here to you, but I would respectfully suggest, and this is, you can look most clearly at the record on record page 10, and where my friend says that, quotes from that statement, it was in the context of parsing the language of the contract. It was not, and in the...
The legal principle is the same, right? We have said previously that you don't need to sign a separate document to be bound, correct?
That's my, yes, Your
That's
Honor.
exactly what we said.
Respect-
And that's what you're arguing here, that you do need to sign a separate document or expressly assume, however you want to put it, to be liable, correct?
Well, Your Honor, under Silman.
Okay, so that argument is that argument, and it was made the last time, and it was made below.
That argument last time was made based upon the terms of the contract. We did not argue Silman. We did not cite binding Court of Appeals authority to you because the parties were focused on the terms of the contract. Here, the antecedent issue is regardless of whether a party...
Why should we get a second bite because it's a related case?
It is a related case. So the law of the case doctrine does not apply here because it's a separate case. Law of the
Why
case.
doesn't collateral estoppel apply?
Well, they didn't raise that below, Your Honor, so you certainly have the discretion not to reach the issue, and because it wasn't actually decided in this case. You resolved whether plaintiffs had adequately alleged that defendants were successors under the contract. Our position is that it doesn't matter whether you're a successor under the contract. New York law prohibits successor obligations, contractual successor liability without an express assumption. They can pursue their common law theories, but they have to prove those up. They shouldn't be able to rely simply on the terms of the contract. Silman, Nicholson, respectfully urge the court to go back and look at those again. Thank you very much.
99 Wall Development versus Consigley.
Good afternoon, Your Honors. May it please the court. Adria Yaron, Cullen and Dykeman for Appellant Consigley, formerly known as Nickel. There's 3 issues on this appeal. First, the lower court correctly found that the underlying plaintiff's damages did arise out of an act of Respondent Higg of drilling a hole in the ceiling through which water leaked and flooded the plaintiff's building. Once the lower court found that, it should have granted conditional summary judgment to Consigley on its contractual indemnity claim under this court's prior holdings in Fitucci v. Durst Pyramid, 20583rd,
Do you know
411.
who's ultimately responsible for that, though? I mean, aren't there different versions of who bears responsibility for having seen that the water doesn't leak through that hole?
The arguments made by the respondent that there may be some set-off or contribution claim doesn't obviate our entitlement to contractual indemnity.
What about the,
argue that they were told to do the hole and then the person, your client, was responsible for making sure that that hole was covered and nothing went in that hole?
Again, those are set-off arguments.
counsel,
They
isn't there an
don't s-
argument, isn't there an argument being made that your client is the sole proximate cause of the accident? And if your client was the sole proximate cause of the accident, that would undercut your position you're taking now.
Well, actually, Your Honor, that question wasn't asked on this set of motions. The order of the court actually specifically said that was the topic of a different set of motions and was actually not resolved on those motions and is currently pending on appeal before this court under
Don't we
docket.
need to decide that issue, to decide these?
That issue hasn't been decided, and therefore, it's
It
irrelevant
hasn't been
to...
decided, so it's still undecided. It could be decided, but so the fact that no determination has yet been made as to who caused the accident, isn't that a still undetermined issue?
No, because it would still be a set-off issue. It doesn't obviate the fact
But
that
why
the
is it a
indemnity
set-off issue
requirement
and not a
was
sole
triggered.
proximate cause issue?
That doesn't change the contractual requirement
Why
that is
not?
triggered by these facts.
If your client is the sole proximate cause of the accident, why would that provision in the contract be triggered? It wouldn't arise out of their accident, it would arise out of your client's.
But again, that still wouldn't prevent the conditional summary judgment we requested under this court's prior holdings in Vitucci and Gregoire and Vargas, which says that's a topic for set-off of another day. It's triggered under the contract, where we're entitled to it under the contract, and we're entitled to the conditional summary judgment.
If you were responsible to close the hole, then why is it set off? It's all your responsibility. It's not a matter of set off. It would be your total responsibility. If that's correct, that it was your responsibility. I'm not saying that it's a matter of law that it's your responsibility, but if it should be found that it was your responsibility, then why wouldn't you be totally liable for that?
Again, that's a separate issue to be resolved on a separate
Because you're
appeal.
asking us for indemnification. You are asking us to find that you should be indemnified, but you should, right? Isn't that what you're asking for?
What I'm asking Judge Scarpula is that under the contract, we're entitled to a conditional grant of summary judgment until such time as the respondent or somebody else proves that we're solely liable.
Where does the contract say that you're entitled to conditional, if you're the sole proximate cause, regardless of whether you're the sole proximate cause?
The contract says we're entitled to the indemnity until such time as they prove that we and no one else was responsible for it. And also, so does this court's prior holdings under Vitucci, under Gregoire, and under Vargas. Very briefly.
No, I don't want you to start a new argument. You have time on rebuttal. Thank you.
Okay, thank you.
Good afternoon, Your Honors. May it please the court. Anthony Scotti on behalf of Respondent Appellant Higg. It's a cross appeal, so I'll address Higg's affirmative appeal first and then address Nichols.
Let me ask you something.
Yes, Your Honor.
The question that I would like to address. I'd like you to focus on the insurance procurement issue.
Absolutely.
There was a requirement that you get additional insured endorsement and it does not appear that that occurred. I mean, it's pretty much undisputed that that occurred, that the insurance you got, your client got, was not an additional insured endorsement. Why isn't that a claim that they're entitled to a summary disposition on?
So for a few reasons. First of all, Harleysville, who was Higgs' insurer, did pick up Nichols' defense as an additional insured.
Okay, but let's say they did. So there's a period of time where they didn't, and that's the whole issue of the defense cost, which could be obtained two ways. The defense cost could be obtained under indemnification theory, but also could be covered under the failure to insure procurement thing. And under the failure to insure, there's no question that your client didn't get the additional insured, and as a result of that, they didn't pick up the defense for 2 years. Why shouldn't they, as a matter of law, get whatever of those defense costs are attributable to their having to defend rather than and not having to wait 2 years to get coverage?
Respectfully, Your Honor, I disagree with the court's position that the additional insured was not included. The contract language specified certain...
What do you mean that it was not included?
I'm sorry?
What do you mean that it was not included? I mean, there's no question the insurance that you procured was not the insurance you were supposed to get. The agreement was very specific that you were supposed to get insurance with certain endorsements specifically listed, CG 2010 paren 1185 or a combination, I won't read all of them, and you didn't get those endorsements.
Understood, Your Honor, but what the contract actually says is those specific endorsements or similar...
But they're not similar because under an additional insured endorsement, it would cover total liability for them whether or not they were at fault, not at fault. As long as the complaint asserted a claim, there would be coverage. But the one that was actually put in was coextensive with the indemnification, which is not the same as an additional insured provision.
Agreed, Your Honor, but
How did your client satisfy that requirement to get the insurance that was required?
Because not only did my client obtain the insurance, their insurer picked up the defense for Higg.
Right,
But not for
that
2
goes back
years.
to the prior 2 years wasn't covered, and if they drop it at some point, then it won't be covered. So why aren't they entitled to summary judgment as to liability on that claim? And then at the end of the case, you'll see whether or not what the damages were that were actually incurred.
There is case law from this court that says that an insurer's refusal to indemnify for loss does not constitute a breach of contract claim. Higg obtained the insurance. Their insurer picked up the defense. Their decision, right or wrong, to deny coverage for the first 2 years
But
or
it
to
seems
threaten
again
to
that
deny
you skip over the step that you didn't get the insurance you were supposed to get.
I
That's
maintain
the
that we did-
breach, not your insurance failure, your insurer's failure to cover it. Your breach not to get the insurance, and I think you admitted. I don't know why we're even going back and forth on this. And you've admitted that you didn't get and you're saying, or at least the way I read your brief was no harm, no foul, because they picked up the defense. But there was 2 years that they didn't pick up the defense.
Right. I don't know that we've conceded that we did not, that Higg
I
did
mean,
not.
I could read from you what you said, which to me sounds pretty much like you did.
But the point that I was making is that the clause in the contract actually says that it has to be those specific policies or equivalent. What was obtained was
It's
equivalent.
not equivalent. The one you got was contingent on whether there was indemnification under the agreement to be coextensive with indemnification. On an additional insured, that's a non-issue. So it's a lesser form of insurance, which is why they were disputing whether or not they had a coverage, and they're still threatening to terminate coverage at some point, which would not have happened, so it's not equivalent.
I mean, the insurer is, to add to that, the insurer is threatening to say, we're done, we did what we were supposed to do, right?
Well, the claims have been resolved with the exception of the gross negligence claims directly related to Nichols' conduct, which...
Your time
yes,
is
they
running
are
out.
in a separate deck action. There has been, which we are not involved in. They have apparently threatened.
Has Consigley claims that it spent $878,000 plus on its own defense costs before the insurer came in, right?
That's correct, but that's defense of all claims and their affirmative claims. That's not just claims relating to Higg.
Well, that's why you have inquests to determine the amount.
What other claims do you say it involves?
There are claims for negligence arguably related to Higgs' work, although we take exception to that. And then there are a whole host of other claims related to other subcontractors and other work performed by Nickel independent.
That has nothing to do with this?
That has absolutely nothing to do with Higg.
And the attorneys are covering those claims? The insurance company is defending those claims also?
The defense costs claimed in the summary judgment motion and the appeal are all defense costs incurred, including expert costs, to analyze and defend all of the claims against Nickel, as well as prosecute Nickel's affirmative counterclaims.
Thank you. You'll have additional time.
Your Honors, I was going to address the breach of contract claim, but Your Honors seem to understand the issues there quite well.
Well, the 878,000, is that all related to Higg, or?
Well, Your Honors, I challenge you to find anything in this record supporting.
Well, that's what I want to ask you. Other than argument, are there any documents or anything else that shows that that amount was attributable to any other alleged negligence?
The documents in support of the claim are attached to the motion papers. They're in the record. Your Honors are welcome to look over them. Counsel hasn't submitted anything
Well, do you say that
supporting the
all of
argument
the
he just made.
878,000 relate to Higg?
It relates to our defense in this action,
Let me
which
go back a
again,
minute.
we're entitled to insurance for.
It didn't answer the question, but before, a precursor to that, when you move for summary judgment on the breach of contract procurement issue, did you only move for summary judgment as to liability? You didn't move for summary judgment as to the amount. Is that right?
No, it was in the motion papers that we were entitled to reimbursement of the 878,000.
But if it doesn't all relate to Higg, why are you entitled to reimbursement?
Relates to our defense in this action, which arose out of
Relates
Higgs.
to what?
Which arose out of Higgs' act, which should have been covered by the insurance that it was required to obtain in
all
our
of the
contract.
878,000 relates to what this case is about?
Under the insurance that Higg was supposed to obtain, according to his contract, we should have been covered for that.
But counsel is saying, no, you were also defending other claims early on with your other insurance. That $875,000 in defense costs was not only to defend the Higg claim, but you were being sued and suing other subcontractors.
No, it's all in this action. And
this action is only Higg, right?
It's a construction defect accident, so there's several
I know the
people in it, but there's a number of
I
parties.
know that the red light is
but
gone
it's
off.
the
What
same.
in the record establishes that all of the 878,000 relates to Higg?
So
And this action?
wouldn't that be a defense that is their obligation to submit some kind of evidence that what we're claiming isn't relatable to what they're required to insure us for?
It's your motion.
We submitted documents that this was our cost of defense on this action, which they were supposed to obtain insurance to cover us for. And they didn't obtain the insurance that was required by their contract.
Any other questions? No. Thank you. You have
you,
1
Your
minute for
Honors.
rebuttal.
Just to address the damages issue again, in terms of whether we submitted evidence to contradict that all of these damages claimed related to Higg-specific claims, we raised this in the appeal. The supporting documentation provided by Nickel was not provided in the discovery. The first time it was ever given to Higg was as part of this motion. So for that reason, we've argued that it's inadmissible in any event. With respect to...
You didn't do any discovery about attorney's fees costs?
We demanded production, but
Oh, but
none
it
of it
didn't-
was ever exchanged.
Oh, okay, okay.
The first time any of these records were provided was, again, in connection, it was an affirmation submitted in connection with Nickel's summary judgment motion.
So are you saying you didn't have the documents, or are you saying there are documents in this record which establish that not all of the 878,000 relates to Higg? Which is it?
Well, I'm saying that Higg is not in a position to know that, but in any event, the indemnification clause in the subcontract becomes once again relevant because there's limiting language in that clause that specifically says that only to the extent that the claims or damages arise out of the acts, omissions, or
That's
breach
for
of...
indemnification, that's not for failure to
Well, it's
procure
defense
insurance.
and indemnification. So to the extent, which is how the court properly ruled, the lower court properly ruled.
But aren't you conflating the indemnification and the requirement to procure insurance?
They're separate claims.
Yes, but Higg is only required to pay defense costs related to Higg's claims, to actions that arose from Higg's work.
Except it's also required to get additional insured coverage, which would have covered earlier defense costs regardless of whether at the end of the action there was liability. That's the problem. Okay.
Thank you.
Thank you.
Fields versus General Conference.
Jay Breakstone, excuse me, Jay Breakstone for the plaintiff respondents in both actions, Pichardi and Fields. I just wanted to take a motion. I realize that my adversary has submitted, but I wanted to take a motion to talk to the court very directly about what's happening here. These are a number of cases. They are a number of cases and have been, and this question has been.
Let me just ask you real quickly. The second department has found that this is not an is not a juridal body that can be sued. So why are we going not to follow the second department on that issue?
Very good question, Your Honor.
Oh, thank you. I appreciate that.
Flattery will get you nowhere.
and you know that will get me nowhere. And you know that's the reason exactly why I want to come up and speak to you. If you take a look at Chestnut, remember Chestnut is decided after discovery.
After hearing, I would not say after discovery.
Well,
Was
obviously
there
they had a hearing
jurisdictional
and
discovery?
They had some, yeah, because
Okay.
you just can't. If you're hearing, you're asking questions. In my mind's eye, that's what it says, and getting answers hopefully. But in Chestnut, I asked the court to take a look at this. Who was not held liable in the jural, non-jural sense? What entity of the United Methodist Church was involved in Chestnut? And I think you'll find that, and it's very confusing, it's not the same one that's involved here. There's a general board and a general conference. One was present in Chestnut, the other is present here. And as you take a look at the cases, be it Barr in California, be it Bethel up in upstate New York, and there's another fourth department case, name escapes me at the moment, but it's in my brief. There are a plethora of ecclesiastical and non-ecclesiastical bodies of the United Methodist Church. And that is done for a reason. I see the red light go on.
You have a sentence to wrap it up, because you only have 2 minutes, so.
That's it. I leave you with this. This is from, remember, in this case, there's only 3 items. There's the attorney affirmation, there's an ecclesiastical affirmation from a priest, and there's the Book of Discipline. Let's look at the Book of Discipline.
No, this is not a sentence. Your time's up. You,
Well,
you can't go into a whole long argument.
I know, I'm responding
No,
to
time's up. Thank you. We're
can't-
familiar with the briefs. The other side's not here, so.
You can't respond to the question?
No,
In
I
a
think you
sentence.
have.
No, you have. Thank you.
You have.
I can or I can't?
You have responded. You have.
I have responded.
Yes.
My goodness, I'm not that good. I didn't even know that. Thank you, Your Honors.
Doctors Allergy versus Valiant.
So may it please the court. I want to address 2 issues in my time. The first is the implied covenant, and then the lack of an objective standard. With respect to the implied covenant, there's no dispute that Doctors Allergy engaged in self-dealing to trigger the earnout. They concede that on page 31 of their brief. When a seller manipulates sales to trigger an
I don't
earnout,
know if they would acknowledge that it's self-dealing as you are phrasing it, but go ahead.
Okay,
They
well-
might put it a different way. but-
okay, but they were the ones who essentially told the doctors, if you buy this, we'll buy it directly from you so that we can trigger the earnout. And actually, the contract with the doctors had a provision that said the doctors had to use it, but leave that aside. The Vista case, both the decision by Judge Rakoff and the affirmance in the Second Circuit, makes clear that when a seller essentially manipulates sales to trigger an earnout, it defeats the fundamental purpose of an earnout, because an earnout only makes sense if the company generates sales in the ordinary course of business. Otherwise,
Didn't they
the
argue
sales
that
don't reflect growth.
They argue that they expressly had the right to generate sales as long as the profits went to Valiant. I don't know if I'm pronouncing it right, Valiant?
That is yes, Valiant or Bausch. That is exactly what they argue. They argue that this was expressly permitted. Now, the reality is, if you look at paragraph 3.1 of the contract, where it describes the purchase price and the consideration, it says $1 and the milestone payments to the extent that they are payable pursuant to 3.2. And 3.2 very clearly says that the payment is to be made when Valiant receives compensation.
Right, but I'm looking at it, and there's an argument about it being ambiguous, and it says, upon sales by purchaser or for which purchaser or its affiliates receive compensation. So it says both of those phrases.
It does, but as Vista makes clear, the language in this contract accounts for how to account for an earnout, what triggers the payment. It does not in any way address what type of transaction is permissible to trigger the earnout. That's what Vista makes clear. That's what was affirmed. And what we have here, Your Honor, is a situation where they argue first of all, they never argued below that this was ambiguous. Silence, as the New York Court of Appeals in Donahue makes clear, can't create an ambiguity. And so if you look at the language here, there's nothing ambiguous about this language. At most, they can argue, as they do, that, well, they were entitled to control their own destiny. But even
why can't it be construed that this milestone can be satisfied either by sales that Valiant makes or any other sales for which Valiant ultimately receives a compensation?
Because as the Second Circuit said, even if that were the case, the purchase would not reflect, and I'm quoting, organic growth through potentially replicable sales, because they have fundamentally changed the benefit of the bargain. The benefit of the bargain under the contract was to figure out a valuation for the contract. They acknowledge at paragraphs 3 and 24 of their complaint that the whole purpose of the earnout is to represent fair value for the business.
But yes, but there are two ways to interpret the phrase for which purchaser or its affiliates receive compensation. If your view of the contract was, as a matter of law, correct, why would anyone have even put that in? Because that would be superfluous and wouldn't make any sense. So, and in fact, I think your like chief financial officer testified, look, as long as we got the money, we didn't care. It was fine with us. That's
Honor,
what he said.
He actually did not say that.
I read it. That's what I read him to
Your
say.
Honor,
You and I can disagree.
No. If I can, very respectfully, that's what their self-serving affidavit claims he said, and then what he actually testified under oath was, I didn't specifically say one way or the other how we would be able to facilitate sales, and then Vandergrift acknowledges at page 2007 of the record that he never had any conversation about self-dealing.
Except the plaintiff says, yes, we did. We had several conversations, right?
Your Honors, the question for the implied covenant is there an express provision in the contract that addresses this? They did not raise the question of ambiguity below, and if you look at the contract, it doesn't say that they can resort to self-dealing. It doesn't say they can't, and that is exactly when the implied covenant is triggered. when
Okay,
a
you have
contract
time.
doesn't express it.
You have
If I-
time on rebuttal.
I
You
can
have
take
time
the
on
other
rebuttal.
issue on rebuttal. I'd like
Yeah,
to
your time's
address-
up, but you have time on rebuttal to address another issue.
Your Honors, may it please the court, Alan Scher for plaintiff and
I
respondent.
just want to ask you, is it true that you never raised this issue, that the contract was at a minimum ambiguous? Is this the first time it's coming up on this appeal?
First of all, one of the things I was going to say, Justice Scarpula, is you're absolutely right. There's two ways to read that, which means it's ambiguous. It's not correct that it was never argued. What we argued was it is not ambiguous.
On your side, for you.
Well, it has to mean something.
Right.
And if they got the revenue, we'll get to the issue of the evidence that you asked about in just a second. By the way, I'm appearing pro hac vice, and I'd like to thank the court for the privilege of appearing here in the city of my birth. Thank you very much. To answer your question is that language has to mean something. And if the argument is it's not ambiguous, which we're hearing from Mr. Lefkowitz today, then we've earned the earnout, and we should have been paid the earnout, and that's one of our breach of contract claims. The argument that we're hearing is that their implied covenant counterclaim negates the breach of contract claim, okay? That would be an affirmative defense, which they did not move on. They did not move on an affirmative defense on the breach of contract claim. Getting to the evidence that you were asking about, Justice Scarpula, it was undisputed that our primary negotiator, Dr. Loff, testified and wrote an affidavit that he went to the prime negotiator for the other side, Mr. Davis, who did not testify about it, did not refute it, and did not submit an affidavit in opposition. He said he couldn't remember at his deposition. He was a former employee who left when this company blew up in their revenue recognition scandal. Okay? He didn't help them at the deposition. That conversation was, if we hit 199,000 units on December 31st, and you don't take the last order, do we get paid? And the answer was no. Well, what if we facilitate sales to protect our interest and make sure we get there? And the answer was undisputed, as long as we get the revenue, which is what that provision says.
I'm just wondering, you know, one of your points here is that it wasn't the efforts they made to market this were not commercially reasonable. But is this interpretation that you're pushing for, is that a commercially reasonable interpretation, that you will generate the sales to get yourself to the milestone?
Fair question, Justice Friedman, and let me answer it this way. This whole case is about the commercially reasonable efforts clause, okay? The reason, and my client testified this, I believe, the reason they insisted on this provision is to make sure they didn't run into the exact problem they ran into, that these folks shelved the business, okay? Is it commercially reasonable? I'm not sure it matters if it was negotiated and agreed to in the contract, which it was. What we're trying to get...
May I ask you real quickly about your claim for breach of the covenant and good faith and good fair dealing? How does that differ from your breach of contract claim?
Well, I think you're allowed to plead alternative theories.
Yeah, okay, but there's a motion to dismiss, and now you got to come up. There's a
Motion to
motion.
dismiss was denied. This is
Right,
summary
You're not
judgment.
allowed to
Hello,
plead
but they've
alternative
appealed
when it's duplicative. You're not allowed to plead a breach of the duty of good faith and fair dealing when there's an express provision in the contract which addresses it.
And-
And arguably, there is an express provision in this contract which addresses exactly what
but
you're asserting in there.
Appellant is arguing that it doesn't address it, and it doesn't count, and those sales don't count for reasons having to do with the doctor's use
Contract,
agreements
the
and other
contract.
things. If they don't count, and we don't have a breach of contract claim for that amount, the conduct can still be a breach of the implied covenant of fair dealing if it impacted our ability to enjoy the benefits of the contract.
Well, if you don't get it, isn't it because you weren't entitled to it under the contract? Because the contract, you're arguing, has a term which addresses this very issue. So if that contract term is ruled in a way that's not favorable to you, then you weren't entitled to it under the contract.
I think we're confusing two things, which is what the appellant has done throughout this case and throughout this appeal. If we don't get the $4 million for the second milestone because the 200,000 unit sales don't count, we lose that issue. We still have a breach of the implied we still have a breach of the
Which consists of
commercially
what?
reasonable efforts.
Well, no, commercially reasonable efforts is different than, what is your implied covenant claim if you lose on the contract claim, which is different than the commercially reasonable?
Because the commercially reasonable efforts clause of the contract does not say what conduct is or is not.
Right, you can't tie your breach of duty of good faith and fair dealing into the commercially reasonable. It's a separate claim.
It is a separate claim.
So that you can't say because there's an issue as to what's commercially reasonable, we're going to call that a breach of the duty of good faith and fair dealing. It sounds to me like that's what you're trying to argue. Maybe I'm hearing you wrong.
Well, I suppose, I appreciate what you're saying, Justice Kern. I suppose the issue is, if we haven't or don't establish the objective standard, which is one of the other issues appellant has raised here, then we don't have a commercially reasonable efforts clause because it's not defined, whether by evidence or by the contract. But we can still have an implied covenant claim because
No, you have a breach of contract claim because it's a requirement under the contract that you use commercially reasonable standards. If that's, and then you can, like, everybody can decide at trial what that means in this context, in this case. Not that complicated.
The last thing I would say, Justice Scarpula, is to the extent that that's how the panel is feeling, the court below, on the basis of 529 facts submitted by the moving party on a summary judgment motion and 229 additional facts submitted by us in response, many of which were unrefuted, found there's plenty here to litigate and try. And by the way, Justice Reed is going to be the trier of fact. This is not a jury trial.
Thank you.
3 very brief points, Your Honor. Number 1, the defendant is wrong. The word ambiguous never is mentioned once.
But counsel, he made a very good point. Even if they don't mention the term ambiguous, if they're arguing it should be interpreted one way, you're arguing it should be interpreted another way, and the court thinks both are reasonable interpretations, then the court can say, hey, it's ambiguous.
But as a matter of law, the court can't look at silence and find ambiguity. You have to
They made, his point, which maybe you could address, is that he made a specific argument as to one interpretation.
And what I'm saying is their interpretation, which is that somehow the parties all agreed that they could control their own destiny, doesn't mean they can do it through self-dealing. It means they could go pound the pavement and try to make legitimate business sales that would reflect the growth of the company. I think the fact that the contract doesn't expressly say they can do what they did, which is self-dealing, puts us exactly where Vista puts us. The last point I want to make is...
Just by the way, in terms of finding ambiguity in the scenario which Justice Kern gave you, the court could find ambiguity.
Yes, under that circumstance. Yeah. I want to just address very briefly, the trial court here articulated that there were lots and lots of factual disputes over whether we had commercially reasonable efforts or not. It's almost like someone says the guy was driving too fast, the other person says, no, he was driving safely. But what New York law requires, Holland Loader makes this absolutely clear, is when you're dealing with something not like just pure negligence or a speeding issue, you're dealing with something like commercially reasonable efforts and it's undefined, the judge has a step 1 obligation, which is to say, what is the standard? And all the judge...
you were moving for summary judgment, so you had the initial burden on that issue, right?
They have, no...
So you moved for summary judgment to dismiss their commercial...
Yes, because they have the burden under New York law. They have the burden. I'll close by simply quoting Holland Loader. The party seeking to enforce the commercially reasonable efforts provision has the burden to establish the objective standard by which the breaching party's conduct is to be established.
Thank you.
The judge never established the standard.
Thank you very much. No, that's not allowed. Yeah, no, that's not allowed.
Thank you very much, Your Honor.
Van Boxell versus Van Boxell.
May it please the court. Linda Rosenthal for the defendant appellant, Chinyu Van Boxell. It is uncontroverted that as a result of this 7-year and 3-month marriage, there were virtually no assets. There was significant debt, however, largely incurred to enable Dr. Van Boxell's medical training through his first residency, his second residency, his third residency, and his fellowship. When Dr. Van Boxell moved out of the marital home in November of 2015, he told Mrs. Van Boxell, "I just need time to think." My client had no idea, of course, that Dr. Van Boxell had consulted with counsel and was aware that there was going to be a change in the law a few months later. Dr. Van Boxell, conveniently for Dr. Van Boxell, filed the divorce in February of 2016. And by doing so, of course, took advantage of the change in the law that rendered what was established at trial to be his uncontroverted $2.178 million of enhanced earnings, marital enhanced earnings. He rendered that, of course, no longer an asset for which he was eligible, or Ms. Van Boxell would have been eligible for distribution. But he didn't defeat her altogether by the timing of his action. The trial court, like the referee before it, erred by not considering Dr. Van Boxell's uncontroverted enhanced earnings as a factor in Ms. Van Boxell's spousal support. In fact, the trial court—
Are you talking about maintenance now?
I am, spousal support, yes, ma'am.
Didn't the court follow the guidelines as to the amount of years of maintenance?
It did not, Your Honor. Neither the referee nor the trial court after it did any kind of calculation. It is uncontroverted that—
This was a 7-year marriage, right?
Yes, ma'am.
And you're asking for 14 years of maintenance.
I am, Your Honor.
That is not the typical amount of maintenance that's
It is not,
normally
Your Honor, that
provided
is for sure.
So is your whole argument that you're entitled to what would be an extraordinary amount of maintenance based on the fact that you no longer got the right under O'Brien to get the enhanced earnings, so therefore you should be compensated for the loss that the legislature decided to do in terms of getting an extraordinary length of maintenance?
We're arguing, Your Honor, that of course the legislature was entitled to take enhanced earnings out of the marital asset pot. But it also preserved the concept in respect of the marital and in respect of distribution, and it remains a factor in post-divorce maintenance, spousal support. The referee didn't take into account any of the spousal support factors, and instead actually credited improperly Dr. Van Boxell for what was predominantly the rent paid during the pendency of the litigation. The only reason Dr. Van Boxell paid the wife and the 2 children's rent during the pendency was because it was garnished directly from his paycheck. It was hospital housing. The referee didn't calculate at all what was the right amount of child support due, nor did she do any kind of calculation in respect of spousal support due during the pendency. There were no interim pendente lite applications made for Ms. Van Boxell during this case. So Ms. Van Boxell had the unfortunate, as she testified, experience during the pendency of the divorce, sometimes seeing money get deposited into the checking account, and sometimes seeing Dr. Van Boxell immediately withdrawing it. She did not have the benefit of any kind of steady.
Wait 1 second. There was a temporary order for the husband to pay the wife. Are you saying that was only child support?
It was, Your Honor, and actually, to be clear, that order—
And that child support was over what, or more than what, if the formula had been followed, he would have had to pay, correct?
That's correct, Your Honor, but
Okay,
chronologically—
so she was getting essentially more than what she would have been entitled to get for child support if she had, if the court had used the formula, right?
I think chronologically, Your Honor, there were no interim applications made up until the time of the hearing. The evidence at the time of the hearing before the referee, there were no interim or support orders or any regular support being paid. A year after the trial concluded in 2019, at that point, because Dr. Van Boxell had notified Columbia University that Ms. Van Boxell and the children were moving out and had made no provision for them financially to secure housing, we had no choice but to make an emergency application. On a post-trial basis, from that point forward, Judge Drager did, in fact, make a ruling on child support. She did apply the $325,000 cap that we're not challenging, and I don't believe the other side is challenging as well in respect of what the decision was ultimately on following the hearing. But that support order was in effect after the trial evidence. And so there's no issue about the—
So I don't know. So what are you arguing about the maintenance? The maintenance was for a 7-year marriage until was
There was no maintenance received, Your Honor, even in 2019, so during the pendency from the
So you're
filing.
saying all the money he paid was only for child support?
Yes, Your Honor. The only money he really paid up until the time of the hearing and prior to Judge Drager's order in 2019 after the hearing, the only money he paid in large measure was the rent that was garnished from his paycheck. There are cases, as Your Honor is aware, Eunice, for
So
example.
then why did the referee in the Supreme Court find that he had overpaid maintenance?
I believe they erred, Your Honor.
And why was that an error?
Neither of them actually calculated how much was due. So if you look at the trial court's decision, Your Honor, although she corrected the income amounts for both of the parties and did an actual mathematical calculation about child support, she did not do the same in respect of spousal support, nor did she make she did not distinguish, between the concept of pre-judgment maintenance during the pendency and post-judgment maintenance. Ms. Van Boxell was entitled to receive steady support post-judgment, and that's a fact. Enhanced earnings ought to have been a factor in that.
Thank you.
Thank you.
May it please the court, my name is George Sava for the respondent. Your Honors, this is a 9-day trial before a referee. It then went before Justice O'Neill Levy, who went through this with a fine-tooth comb and made determinations. She adhered to the statutes every step of the way, and the evidence at the trial itself, and which Justice O'Neill Levy reviewed after the fact, bore out her decision. There's nothing in the decision that was wrong, underpayments, overpayments.
So wait, the judge calculated 26 months of maintenance, right, under the DRL, correct?
Yes, correct.
And was that 26 months of maintenance paid?
It was paid. She found it needed to be a set-off because it was paid prior. And the referee said because of the payments that were already made, that it was a wash.
What payments were already made?
Yes, because that's when Justice O'Neill Levy in her order said she was upholding that previous payments were made because of the overpayments that were made.
And you're saying that those payments, counsel is saying those payments weren't for maintenance, they were for child support.
Counsel is trying to argue that that's free money. But here's the thing. Counsel is also trying to get 14 years of maintenance. Spousal.
100%. I'm just trying to figure out the maintenance that was awarded.
The money that was paid, although counsel would like to couch it as strictly as child support, therefore overpayments, therefore it's waived. It was not. It was payments that were done. There were child support payments.
For both child support and maintenance.
The respondent was providing money for the
family.
The appellant herself. That is why, and all this came out at trial. But again, counsel wants a third bite at the apple here. Counsel now wants you to go back and review 4,000 pages of testimony in terms of what happened and what was before the court and what the referee and Justice O'Neill Levy determined was actually right.
Opposing counsel seems to be arguing that she was entitled to anything up to the time of judgment, and then she was entitled to maintenance after. What's your response to that argument?
That she's not, that there is a cap. What is spousal support?
Is pendente lite usually offset at the end?
It was offset. Justice O'Neill Levy.
It's not that you get pendente lite and then you get a full judgment after.
This is not like a retirement fund. And what also came out at trial and what was, and I don't want to be careful how I say this, but Justice O'Neill Levy.
Be careful how you said it.
referenced inconsistencies in the testimony by the appellant at certain points in the trial. That was taken into account too. We referenced those in our papers.
Where the referee found the husband to be more credible than the wife.
Yes, Your Honor.
We read it.
Okay, that's all. My point is the trial court makes these assessments. They're the ones that can make the assessment as to credibility and the facts and everything else.
Your friend's argument is that the court didn't detail what the amount is, what the number is.
That wasn't my argument.
19 months. That's what she's arguing.
Oh, that's what she's arguing, but the details are there. I mean.
Well, I'm looking at her decision. There's no numbers here.
Well, there are numbers when you get into the decision, and I think it's page 7 or 8 on the record, Your Honor, gets into her determination as to the $600,000 that she was taking it from $200,000 to $600 and change. because of the net worth statement. She was going through the calculations based on that 638,000, whatever it was, over $600,000, and then basing the child support calculations on that as well. So really, the only issue here, and it's on page 7 or 8 of the record.
So I'm on page 7, I'm looking at spousal support, there are no numbers.
Do you see before that, Your Honor, where it says 638, where she gets into
She maintains income of 625, is that what you're
625? Yes, Your Honor.
All right.
So, and what she based that on was the new numbers, his new net worth statement. She argued, she made the point in the order that the referee didn't have these new numbers before her when she made her decision. She was now taking his current earnings and applying it through the spousal support, child support, and everything else.
But the judge did take those numbers into consideration in reducing the wife's income from 100 to 50, and then adjusting the debt from 50 to 93.7, right?
Yes, the judge and then redid all
So
the
there was that calculation that did take into account that over the years the husband had been making more money.
Well, they were taking into account, and she was taking into account exactly what he was making. Anything beyond that, the only thing I would, if I could just quickly say, was I think the issue of, because both raised the issue of attorney's fees, because they were ordered payment from the respondent to the appellant, because those. Yeah, yes, correct. And I'm not arguing against that. What I'm arguing here is that issue, I think, should go back to the trial court for determination, because there was, as we pointed out, 3 attorneys coming on behalf of the respondent, the appellant, for a simple conference.
Sounds like a matrimonial action.
Yeah, I know, but also hourly fees that were higher than what were put in the retainer agreement as well. Thank you.
Your Honors, I want to say that when Judge O'Neill Levy, in her decision, recalculated on page 6 the child support, she did not go ahead and recalculate anything in respect of maintenance.
I think that she found that it had already been fully paid.
But
She
it is
made a
impossible.
determination that there was an overpayment, and therefore no recalculation needed to be performed because no further amounts
The
were due.
referee similarly, excuse me, Your Honor, apologies, but similarly, the referee did not do any calculations and double counted what is undisputably the only money that was paid during the pendency was the rent, and then some Amex payments that were made, about
Some
$600 a
reserve
month.
paychecks, weren't there some reserve paychecks that were turned over?
Nothing on a regular basis, Your Honor. The only thing that was
Doesn't matter whether it's a regular basis. When you do a calculation, you have to count
absolutely look
everything
for
in
anything that
and
was paid. There should
determine.
be. That's correct. But what the trial court said was, look, we're going to recalculate the amount of child support due. She didn't do that calculation in respect of the spousal support.
Thank you.
I will say it's a grave travesty of justice if this woman has given 7 years and 3 months of her life to enable the enhanced earnings of Dr. Van Boxell, and if he alone bears the fruit of that investment and her contributions, which are irrefutable. Thank you.
Skidmore, Owings, and Merrill versus New York City tax appeal.
Good afternoon, Your Honors. May it please the Court, Timothy P. Noonan for petitioner appellant Skidmore, Owings, and Merrill. Your Honors, we're seeking a reversal of a city tax appeals tribunal decision that denied the petitioner deduction for a payment made to a special related entity called the DISC. Now, we think we're arguing that the tribunal's decision was wrong on both factual and on legal grounds. So, Your Honors, on factual grounds, the first problem with the decision is that the tribunal based its denial of the deduction here on a factual issue. It said this really wasn't a payment to a DISC, this special entity called a DISC. It really was a payment to petitioner's partners. It was a payment to the partners. But to get to that conclusion, the tribunal found a new fact, a fact that wasn't found by the administrative law judge below, it wasn't advanced by city's council, but the tribunal found that the ownership of the DISC was wildly disproportionate, that 3 partners owned a lot more of the DISC.
Counsel, why does that matter to the ultimate determination?
Well, it matters.
Which is that there's no question that the DISC did not have any employees, did not perform any services, and there's nothing incorrect about that factual determination, which is the basis for why the tax tribunal did what it did.
Well, but I think they use this factual finding about the disproportionate share to find that this was
They
really for
specifically
partner
said they
services.
didn't, that their ultimate finding was not dependent on how the shares were allocated.
Right, but the question here for the deduction is whether the payment was for services by petitioner's partners, right? Not that it was for services, it was for by petitioner's partners. On a factual basis, the stipulated facts say this was a payment for deemed services by the DISC, not by petitioner's
But
partners.
that's a stipulated fact, but it's not really a fact, it's a legal conclusion, isn't it?
Excuse me, Your Honor?
Isn't it really a legal conclusion rather than a fact? Because whether or not they had to follow federal law or not is a different issue, and I'm sure you're going to argue that. But it does seem that it's somewhat undisputed that no services were performed by the DISC on a factual basis.
I agree, Your Honor, yeah.
So that's undisputed. So, and that was the basis for the holding they came to. Whether or not they have an obligation to follow federal rules, and this is a different issue, which I know you're going to argue, but factually, there doesn't really seem to be a factual dispute about what they held.
Well, Your Honor, which is interesting because the tribunal seemed to want to make it about the facts. They said our holding
Are you
is.
referring to the fact that they point to a 2004 IRS filing form, whereas we're talking in 2011 and 2012, so that they just relied upon the wrong year?
Correct. That was clearly a mistake. Yes, but the
Does that
tribunal.
matter to the ultimate outcome of things?
Right. Well, I guess the point is that the tribunal made this about its factual findings about petitioner services. It got that fact wrong. It mentioned it 11 separate times. It got the stipulated facts wrong. But again, that's the factual issue. But it's just that Justice Friedman.
But how does that get you to a reversal in an Article 78?
Right. What gets us to a reversal, one, is that the factual decision wasn't grounded on substantial evidence because of this mistake, because of the
But
stipulation.
again, there's no question that I'm repeating myself, but the factual basis for the decision was that no services were provided, and that's undisputed.
So, Your Honor,
that doesn't seem to be an erroneous determination, factual.
I think you're right. Is a mixed question of fact and law. Let's turn to the law, perhaps, Your Honor. So the legal issue starts with this really important concept. The city tax here is tied to federal tax law. It uses federal taxable income as a starting point. The terms and conditions are supposed to mean the same thing, and valid federal deductions are supposed to be treated as valid deductions for UBT purposes. Then we look to Section 170 of the city charter, which says that the tribunal has to respect decisions of federal courts on similar issues.
Let me ask you something about that.
Sure.
Are there any cases out there at all which address that precise issue of whether the city is bound to apply the same federal DISC tax shelter to the city UBT taxes? Are there any federal cases that address that specific issue?
Not on the DISC issue, Your Honor.
Isn't that what we need to determine whether or not the city is required to follow federal law on that issue?
I don't know, Your Honor. The issue under the city charter is whether the tribunal is required to follow precedential federal decisions on similar substantive legal issues. And Your Honor, the substantive legal issue here is whether the economic substance doctrine, the idea to say that, you know what, if we follow the money, really all the money went to the partners, whether that doctrine can be used to the DISC structure. And 3 federal appeals courts have said they can't do that. The IRS can't use economic substance doctrines to say, you know what, this is really a payment for DISC services.
Where does it say under the federal precedential law that the city is required to follow federal law about what to tax or not to tax?
Well, I think it's the...
'Cause that's the real issue.
Right, but I think that the city law ties itself to the federal. The federal law says
Do you start out under Administrative Code 11-507 that the city is obligated to follow federal tax law?
Yes, Your Honor.
Then the question is whether 11-503 gets them out of it here.
Correct. And 11-507...
How does 11-503 make us get to where you want us to go?
Well, that 11-507-3 gets the city to where it wants to go. We're saying that that provision, which
I
explicitly
meant 115073, I'm sorry.
yeah, 115073 requires that there be a payment to partner for services by the partners. There were no services by the partners here. Factually, there are no services by the partners, and legally, again, the federal courts have held there's no economic substance doctrine that can be applied to say, well, this is a legal fiction. This was created by Congress. It's supposed to have no substance in all form. It's not a bug, it's a feature of these things that they don't have economic substance. What the tribunal said is, well, we're going to look past all that. We're going to look to the substance and say, really, it's a payment to a partner. I think a very interesting decision that the tribunal and the city have cited in support of their position here is the Horowitz decision, and there's a couple of other ones. In the Horowitz case, what happened was we had payments to a retirement plan. It wasn't rights to the partners, it went to a retirement plan. But this court said, well, because that was a payment for the benefit of the partners for partner services, you can't deduct it. You have to add it back. But the key distinction, Your Honor, is that it was for partner services. The federal deduction in those cases was premised on services being provided. Here, the federal deduction was not premised on any services at all. And so it can't be added back. Thank you, Your Honor.
Good afternoon, Your Honors. Assistant Corporation Counsel Adam Dembro for the respondent, New York City Tax Appeals Tribunal.
So just to look at this case broadly and taking an overview of it, correct me if I'm wrong, what this case is about, the IRS code set up this provision in order to support having these businesses do business abroad to address a trade imbalance, and the IRS code says you get the benefit of a lower tax rate by distributing it as a qualified dividend to the partners. And the city comes along and says, we're not going to pay attention to that.
Well, the first thing to understand, Your Honor, is that the federal tax law and the city's tax law are not coextensive. And although it is the case for the city's UBT that...
But generally, under 11-507, you are supposed to be following the federal tax code.
That's the starting point, Your Honor, but it's only the starting point. 11-507, the preamble, actually has two requirements. The first is that deductions must be directly connected with the taxpayer's business, and the second is they must be allowable for federal income tax purposes. And if you satisfy both of those requirements, you still potentially face a deduction being added back under the enumerated list.
And this is not under the enumerated. This does the enumerated list doesn't specifically talk about this, correct?
About the DISC, Your
Yeah.
Honor, it does not.
Right. So if we just said, well, it's not under the enumerated list, it does meet the general test. So why aren't you treating it the same?
Because, Your Honor, it does fall under the enumerated list.
Okay, so tell me what subsection of the enumerated list says DISC?
No subsection
None.
says DISC.
Okay. So then what?
But 507.3 says payments to partners for services or for use of capital cannot be deducted. And that's a specific divergence from the federal tax law. And
Payments to partners for, say again, the whole thing.
services or use of capital.
And you're saying because this was essentially a go-around for payments to partners, that section applies.
That's correct.
And to buttress that conclusion, you rely upon a 2004 form, even though we're dealing in 2011 and 2012.
So that's actually not correct, Your Honor. The 2004 form to which you're referring was when the tribunal was considering this matter on appeal from the administrative law judge's determination. They looked at the years at issue here. Let me take a step back and say are 2011 and 2012. And
so why were you considering a 2004 form? I mean, I know you say at the end that all of that didn't matter, that just as a matter of law that you had a right to do this, but in coming to your factual conclusions, why are you looking at a 2004 form if we're considering 2011 and 2012?
Well, the tribunal looked at the wrong year, and there's really no dispute about that. 2004 was not the relevant year, but
doesn't that lead to certain conclusion as to the redistribution of income between differing partners, some of whom are no longer even there?
It did lead to that conclusion, but that conclusion does not affect in any way.
So why do you spend so much time on it if it has nothing to do with your decision?
I really have no answer for that. I
mean, it's not like you said it in passing. It was substantial.
It was something that caught the tribunal's eye, and because they were looking at the wrong year, they spent more time on it than was necessary. But it's also the case that the tribunal pointed out in two places that even if that wasn't the case, even if the distributions to the partners from the LLP, the petitioner here, and the qualified dividends from the DISC, even if they were the same, the conclusion would be the same, which is that these are payments to partners for services the partners rendered. The other thing it's important to point out is in terms of...
Basically, and correct me if I'm wrong in the way I see this, basically it's that the IRS code meant for this not to be taxed the way the city is taxing it, and the city just decided to disregard the economic considerations that the IRS code reflects.
Respectfully, Your Honor, that it's not correct. What the IRS code requires, and remember, under the IRS code, the taxpayer is not the LLP. There is no unincorporated business tax at the federal level. The taxpayers are the partners. And what the DISC provisions of the Internal Revenue Code provide
allows the workaround to reduce the tax rate
for the partners.
I mean, I think it might be fair to the IRS code engages in this legal fiction in order to get to this reduced tax rate for what the IRS code sought to accomplish.
That's right, but recall that what the DISC provision does, it takes part of the compensation that the partners would otherwise receive from the LLP, from the partnership, pursuant to the partnership agreement. It takes some of that compensation, which is subject to a higher tax rate, and it funnels it through the DISC. And here, there was abundant facts in the record that the tribunal pointed to say 100% of the commissions that were paid went right through the DISC to the 14 shareholders who were also the 14 active partners. There is the whole purpose of it is to compensate the partners for their services at a lower tax rate, at the rate that's applicable to qualified dividends.
Thank you.
Thank you.
Your Honors, three things. First, on that last point, yes, 100% of the money did go to the partners, but it still has to be for services performed. That's what the UBT rule is talking about. And Justice Scarpullo, you're exactly right. It's not on the list. It's not on the enumerated list of things they get to add back.
Well, how do you explain then counsel's statement? It is on the list. You can't pay to partners, and this was a payment to partners.
But it wasn't, Your Honor, respectfully, it was a payment to a DISC for
yeah, okay, but right. But I mean, so the city is saying, sure, for federal purposes, we make up this thing to get you to work, to do work internationally. But the city of New York doesn't have to make up that fiction.
It does when it ties its tax to the federal code.
But it's it doesn't. We're not. New York City of New York is not required to tax the way the federal government is.
They're not, but the statute, Your Honor, says that we use the city uses the same terms and definitions as federal, required to respect federal deductions.
Except all those exceptions aren't in the federal code.
Right, but that's the point. The
So
DISC
that
thing
is
is
the
not
point.
on the list. The DISC thing is not on the list. And what's interesting is The city has addressed discs for corporate tax purposes. We talked about this in our brief. They have rulings and guidance. There's no statute, there's no ruling, there's no guidance, anything about discs in the UBT context. They just haven't addressed it. It's not on the list.
Thank you.
Thank you, Your Honor.
Thank you very much.
Nice to meet you.